Wired thoughts on a spinning wheel. Machine beats that I can feel.
Welcome, everyone. I'm so glad to see so many people here and online. And I would like to start the conversation off for this session, which again is about the copyrightability of AI-generated works, with Matt. Is it Henninger or Henninger? Henninger. Because he works in the music industry. And so for those of us in the room who are more law than music, I thought it might be helpful to get some background information on the variety of ways that AI is being used to generate and inform music.
First, thanks all for it's really great to be here. So as mentioned, I have about 15 or 20 years sort of in the B2B music tech licensing space, and introducing sort of what's happened, the conversation. So my company, just quickly, we have a B2C app called Moises, which has a little over 50 million users today that really leverage a series of AI tools for practicing, and we've really been exceptional to watch, right? From a relatively small group of people to 50 million has shown sort of, and something I'll speak to about the change of musicians to creators and what's happening there. But we also have a B2B services arm, which provides technologies, sort of about 60 AI models to different companies around the world that are licensing these for different purposes. So this can be everything from identifying music and replacing music in broadcast to aiding practice and things like that. But sort of looking to introduce sort of what I'm seeing, there's been a seismic shift in the last 2 years in sort of the depth of knowledge and just in the questions that are being posed on how AI technology and how these models are finding their way into the music industry. I think 2 years ago, when I'd speak on panels, the questions would be very binary, very black, white, very good or bad, right? Are you taking my stuff? Are you recreating it? Are you prompting new music, right? There's like a difference between sort of complementary AI or AI that can aid a creative process, and then there was sort of the generative side. Sorry. And so it's the questions hadn't caught up to the technology, so there seemed to be this disconnect between how it was being used inside of the space. Since then, now looking to today, the questions are much more nuanced. They're much more about how models are trained, how they're applied, where the data is coming from. It is how companies and services are using this has changed considerably. The other big shift that we're seeing is this changing of the definition of musician and creator and the blurring of the lines. And it's something that I think John's going to end up speaking to a bit today too, is the author pool is expanding exponentially, and it's been a goal of DSPs and services and companies that are applying this technology. They want to find a larger creator pool, in my opinion. So they don't want 3 million musicians, they want 5 million, 50 million creators who can create new things, right? And they're leveraging generative AI tools to try and aid that, speed that up to, if you can hit a button and get 60% of the way through an ideation of a sound recording, or even, a melody for a composition, like how can I speed that up? How can I increase engagement process? So I think that's a lot of what, is fascinating us right now. Is it's not black and white. It's sort of these shades of gray inside of it, of like, how much of a generative AI tool could I use to speed up my creative process, to create more works, we're even seeing musicians today, in order to survive, they're creating multiple versions of the same song to post on social network because one will hit and one won't. So they'll create 20 versions of the same thing. They'll watch their own statistics, and then they'll augment how they record and what kind of genres they play in and that sort of thing as a way to become competitive. So we're seeing a much more nuanced and much more thoughtful way of applying it right now.
Great, thank you, Matt. I'd like to turn now to John Riley from the U.S. Copyright Office. John, can you lay the groundwork for us as to the issues that AI is presenting for the copyrightability of music?
Sure. And first, let me also say thank you very much for having me. I appreciate all the hard work done in the background to get us here and putting this program together. And thank you again. A few years ago, I was at an event in LA and met a friend of a friend and told them I worked for the Copyright Office. And they said to me, well, I don't register anything, so I don't know what I would talk to you about. And it was kind of flippant and weird. And I thought like, and I was like, I don't register anything either. But, as it turns out, we do. That's a large part of what the Copyright Office does. And unlike a lot of other countries, that's a little bit unique, right? So we get applications for registration and we review them for copyrightability. And so we have already started addressing those questions and have addressed, edge cases in a lot of different areas over the years. Of course, AI is really, I don't know, for law students here, it is just the ultimate kind of law school hypothetical. It seems like these circumstances are written for a final copyright exam. It's just so many permutations that might change the answer. But it's complicated a lot of things because in some ways, AI is similar to kind of how we've addressed things in the past, but it's also very different in other ways. So, for example, in the copyright world, and in the music world, we talk about musical works and sound recordings, different types of works that have different types of rights and owners. But AI might work with those differently. So, and we get applications for works now that have sound recordings with elements of AI that have been used to edit it, or some people might have had musical works, the lyrics generated by the AI, and we have to figure out how to deal with those. But going back, it is a little bit similar to how we've dealt with things in the past. First is the question about, does something that's not created by a human get protection at all? And then the second question is, if that is true, how much of, or how does it interact with the work and still get protection? And at the office, what we do, we decide if something's registrable, which has a couple other components, but one of the core components is, does it qualify for copyright? Is it an original work of authorship, right? And so those are the questions we've been generally dealing with. And for the most part, what we've been focusing on is the authorship question. We'll talk about this a little bit more in a couple minutes, but the question of, what would AI, under any circumstances, something created by AI qualify as an author under the statute? The other piece about originality is something that I think is discussed less, but is also important. Originality means, is it own its origin to the author, but also is it not copied from anywhere else? And that's another question that I think people need to think about with AI and AI trained works. So that is kind of a broad view of what I work on and maybe some things to think about, but I'm sure we'll talk about more shortly.
Thank you for that, John. And now I'll turn to Professor Mattioli. And since we're sort of in the realm of giving general foundation, I'm going to ask you to talk about your ideas as a scholar on the issues of AI and copyrightability. And I think this question of authorship is a really important one, obviously. And so do you have concerns about extending the concept of authorship to things that are made by computers, and what the ramifications might that be?
All right. Yeah. And first, I'll just echo the comments made by some others here. It's wonderful to be at such a wonderful event on such an esteemed panel. So I would like to talk about two things. When you ask, are there concerns about things other than humans being credited as authors? There's one point that connects to work that I've been doing, and it's the use of AI tools with by people with, I guess, what's broadly called neurodivergent traits. So ADHD, autism spectrum disorder, dyslexia. And I've written about the use of AI tools by people who fall within this category in other creative fields. So, authors and video game makers and actually filmmakers. And it turns out that there seems to be real potential for AI to help people get over some hurdles that otherwise might have prevented them from becoming authors. So connecting back to points that Matt made, it looks like there's an opportunity to expand not only just the raw number of authors, but the types of authorial voices out there assuming AI is going to assuming that copyright is going to, still apply to works with some level of AI intervention. The question is, and others have raised this point, it's probably a central issue, how much AI involvement is going to, pollute what might otherwise be, I'm using the word pollute a little facetiously, but, pollute what might otherwise be like a human created work, what we think of as a work meriting copyright protection. So there's an opportunity there that I would love to talk more about. I don't know if others on the panel might have thoughts or people in the audience have thoughts, but it's kind of a provocation. Another point I'd like to make, actually, it is away from your question, but I'd like to put it out there. The panel today is about copyrightability. And when I think of copyrightability, I'm thinking of like the threshold requirement. What sort of things do you need to do to get a copyright? And hand in hand with that is a question of, what sort of incentive does copyright law want to create? So along with those questions, is the goal of copyright law purely just to incentivize creation, or is it also to incentivize the dissemination of work to the public? The early versions of the Copyright Act were, an act for basically like the spread of knowledge for, learning. And historically, this overlooked part of copyright law, an overlooked goal of copyright law, has been the goal of trying to disseminate knowledge. And by and large, that goal of dissemination has been left up to market forces. But increasingly, in a lot of creative fields, including music, AI is being used in the, not necessarily at the moment of creation, but in this pipeline of production and so in the context of music, mastering. I'd love to know more about, Matt, you mentioned the use of AI to like create multiple versions of songs. So mastering, marketing, trying to get yourself discovered as an artist, and ultimately even like creating marketing materials, customized marketing materials, maybe a customized cut of a song for a certain audience. So to me, that's really interesting because it relates to this secondary, largely overlooked or less often discussed goal of copyright law, dissemination of creative works to the public. So talking about that pipeline and the facilitative role that AI might play is really interesting to me. So I'll stop there. I could talk all day about this, but we only have so much time, so I'll stop there.
Thank you, Mike. Well, Matt, I think I'll let you go back to you, given Mike's questions about the interesting uses that people are using AI for, and I'm just going to let you riff on that, if you would.
Sure. So it's interesting. So you talk about like mastering, dissemination of different like marketing. We found like multi-versioning. There's been a kind of a visceral response to it on the music side. So we've been asked to create synthetic voice models so that we can essentially take a song and put it into a different language. And we've done it. But honestly, the visceral reaction to it is so strong from everyone that listens to it that I don't actually see it as a viable solution. I do see it on changing the language of dialogue, right? The idea of saying, and so we did a project at a company where we did a commercial for Papa John's and Shaquille O'Neal to make Shaquille O'Neal speak Spanish. And we got a phone call in the middle of the night that essentially, we got a phone call that essentially there had been a post-production error in creating the commercial, and it had like 3 days to be shipped into Latin America, and it was in English but with only Spanish subtitles, and all of that, they went nuts, so we can't have it. So we were given the audio of the commercial shoot. We take the lapel mic, we create a voice model of him from that day, and because he was nasally, like he was actually a little sick that day. And then we said, all right, well, which dialect would you like? Like, from where do you want the accent to be? And they said, oh, we'd prefer it be from Mexico in this region. We're like, okay. So we hire a voice actor, have the dialogue spoken in the properly, and then you port the model to the Spanish speaker, and you end up with the proper dialect inflection and that sort of thing. And it shipped, and it ran for months, and everyone was really happy with it. But it worked. But and you listen to it and you're like, okay, like that's actually Shion. That felt right. However, if you apply that same idea to your favorite song, like the idea, there is just a visceral reaction that we've seen. Now, we are seeing the idea of like singer-songwriters who are trying to pitch music. And they say, I've written a song, but maybe it sounds better if it was in country with a female vocalist. And maybe it would be different if this kind of like these kind of ideation creation tools, we're starting to see that happen quickly. Producers are loving this technology. So the idea of like a producer has to create like a 6-part vocal harmony underneath the lead singer, like a vocal stack. Well, instead of having to go through that process, they'll sing all the parts themselves, use voice models, change the timbre all the way down, and it's buried in the mix. You never know. It's not the actual lead, right? But it supported the creative process, pushed it out like anything else. So there's been that, and then same with the marketing. The idea of creating 30 versions of something that are spot specific, right? That can do so. But again, the art, and I think the respect for the art, and from what we're seeing, it's like everyone wants that. Everyone's like, I'd really love every song to be in every language. But when you actually apply them, when you do it, everyone goes, it turns out I actually like was really connected to that piece to begin with.
Do you think that this is it like an uncanny valley kind of effect? You can tell that it's artificial when you hear someone, let's say, a song produced in a different language, and I'm asking this partly wondering, like, is this a technical hurdle that you think AI is going to get past? It'll somehow be able to, in a year, 5 years, make a more pleasing, less creepy sounding.
Probably, but like there's just a way Freddie Mercury sang it. There's just a way, right? There's something in there that is beyond the language, and it is the performance, and it is the mix. Like for mastering, there's reference mastering, saying it's like, give me a recording and I will pull a bunch of attributes about how it's mixed and balanced and apply it to another. So like take those ideas, right? But that's different. That's just like how the bass sits against the drums and things like that. But I think that the more we see this played with, the more it's like there's more than just the lyrics. There's the actual performance that is on tape has a real significant value. And I think technologists wanted to think that they could push through that and create every song in every language. But once it's actually listened to, it's like, oh yeah, that's just not doing the same thing, right?
That's super interesting. I could just add, like, so I wrote this article last year about industries other than music, really. I mentioned it a few minutes ago. And I found, like, in movies, and like you said, with dialogue or written non-musical language, there are all of these uses of AI to translate in order to ultimately disseminate works to more audiences. And that seemed like a positive role from a creative standpoint to reach more people. But that's really interesting that maybe music is just, there's something human, like the way Freddie Mercury sounded, you can't get past that with technology. That's really interesting.
And just like quickly on the technology side, like we're not modeling voices. There's a lot of ways now. I mean, there's tons of companies that'll let you put in 10 minutes of audio and recreate 5 minutes of audio and get a voice model, right? Like on the music side, we're actually modeling down to the microphone. So you can say, and we've done that project where we had a major label artist was doing a live performance, and they had just like me, terrible microphone etiquette, and a couple times got way too close to it and way too right, and forgot some lyrics. They asked us to model his voice and the microphone, but they wanted us to pull a microphone model from a studio because they know he sounds better with a Neumann, use something. So when we actually reprocessed that audio for him, it was his producer sang the parts that he messed up, fixed the language. So that went through a model, right? And then the entire performance went through essentially like a microphone cleanup model to put a better sounding microphone on it. And then it was produced. And it's all buried in Pro Tools or a DAW, like, and what's crazy is like these approaches have been around. Like experts, professional audio experts have been able to do this stuff for a long time. There's graphs of what those microphones do and they can apply, and it's a plugin in a DAW. It's just getting easier. And now it's like, oh, I can just hit that button. And again, it's the democratization of some of these really pro audio techniques that are like starting to get everywhere.
Matt, if I can ask a follow-up question to this. So it sounds to me like at this point in time, we are seeing AI largely, we are still seeing mostly human or AI supplemented human creativity. Am I saying that well,
Yeah.
clearly enough? Okay. Do you foresee in the future a lot less human involvement, where a creator might just prompt an AI, hey, write this song? And then, John, I'm going to say from the Copyright Office's perspective, where's the line? Where do you see the line going
So
between protection and not protection?
I think you're seeing my musician colored glasses, and also who I've chosen to speak with about this and who I've chosen to work with about it, because I'm a musician. Like that's not going to go away. Like, and I had to align myself with technologies that I thought were benefiting that process and were respectful to that process. No, there's a huge push to prompt base, like give me 2 sentences, give me 3 words, and create music at scale. And it's being used in a myriad of ways. I mean, someone's like, I want lo-fi music to study to. Great. There's also services that are saying, and this will go right into John's, like there's services that are going, well, there's no copyright. I don't own anything. Like I'm going to augment my catalog. I'm going to take away human created music and start to tip the scale of what I use for financial benefit, because I don't have to report and pay on it. Right. And so there's that. And then with Suno and Udio, which are the names you're hearing the most about, like the iterations of those user experiences have, I a year and a half ago, I went in there and I wanted to create for my band. My band was playing this terrible bar, and I wanted to surprise the band. We're not very good. And I wanted to surprise them with walk-up music. So I was like, all right. So I went in and I went into Chat GPT and I was like, give me some lyrics about like cat shirts and whiskey and something really silly, for the band. And it started to create. And I was like, oh, this is okay. And then I went in and I was like, I want this to sound more like Toto. Make this sound more like Toto. And it spit the verse out and it spit a new segment of the song out. And the lyrics went straight to being down in the Serengeti, like immediately. And I just sat back. I'm like, this isn't, you aren't even pretending like where this came from, right? That's now gone. Like that, they're slowly removing, right? That like all of a sudden you can't do that. I can't go in there now and say, make it sound like Toto. It's like, we don't understand who that is, right? But on the flip of that, from the technology part of my brain, in order to tell me that you can't do it, you have to know what it is, right? So, and we've heard anecdotally from some artists that those companies actually have models that will instantly recreate the sound of their bands to a point that they're uncomfortable with, and they're now trying to solicit artists to sign up for that, to say, hey, go into this more advanced model and let me create things just like you. And they're trying to get artists to opt into that, which is odd. So I think there's going to be a huge, huge push into that area.
So does copyright protect it, and should it? Let me back up a minute and talk about kind of just copyright generally. And like I said, this is very new, but it's also kind of nothing the same. If anybody remembers back in the day when people started using kind of sampling, right? If someone was to get, and they would have to get permission to do this, but get, samples of song, maybe put it into a hip hop song, the resulting song might get copyright protection, but the underlying samples wouldn't. Similarly, if you were to take a public domain poem and record a song, your sound recording would get protected, but the underlying lyrics that were pre-existing wouldn't, right? Like they're already in the public domain. Taking those kind of ideas, a couple of years ago, we said we should update our registration guidance for AI, and it lines up very similar with these concepts, right? If something is not protectable by copyright, you have to disclaim it in your, this is a short version, but disclaim it in your application. And if you don't, you won't get registered. And that has just been the way it's been for a while. But this means that, the Copyright Office views that works created by 100% artificial intelligence or portions of works are not protected. Those portions are not protected by copyright. And again, we're talking about, musicianship and technology, and there have been tools, to edit music or to create, the 808 is not a new drum machine. People have used it in millions of songs at this point. People have used Pro Tools all the time to edit their works. It's not that music is against technology. I mean, since Dylan went electric, right? Let's be honest. But we are pro human creators in the copyright world. And I think the reason is that copyright's underlying kind of concept is this incentive system, right? We give authors exclusive rights for a period of time. They are incentivized to create new works, and that benefits the public generally. That's the easy math on why we have copyright. So maybe there's a new, regime that we could create that would protect AI. But how many here think that there shouldn't be a human element in a resulting work, and you should still protect it by copyright, the legal regime out there right now?
So are training off of tens of thousands of songs. Do those authors have any rights to licensing revenue to be compensated for the use of their songs without their permission?
I mean, that is a great question, I think, maybe for the next panel, but I'll also preface, I am a lawyer, but I'm not anyone's lawyer in particular. So those questions are hard to answer right now, but that's something that the courts are addressing. I would encourage you, that's going to be the core topic of the next panel. So stay tuned for that.
Do we need copyright for AI? Or does AI, in whatever form, have enough of its own basically profitability that it doesn't need protection?
I think
I don't know who that's a question for. Any of you.
That's what I was going to ask, actually. So yeah,
copyright is the way that we incentivize humans to benefit the public, but you can benefit the public on your own. You could even dedicate your work, that would otherwise be protected by copyright to the public. There are ways to do that, but the copyright, what it does is because it incentivizes those authors and it gives them exclusive rights, they can license those rights. They can get paid by those rights. And what we were talking about before is, well, what happens when there are no rights in the work? Are those going to be copied, and listened to? And that is, some people may think that that's a problem for human creators because it's competing in the same market. Some people might say that's a feature of the AI technology, right? So it's hard to say. Do you like AI generated works more than you like human created works? That's something to think about. The other thing we're, to discuss, although not in depth, is that there is this concept, and it's not specific to music, that when AI trains on works, it gets better results the better works that you trained on, and human works are generally better than AI. And when AI trains on AI outputs, it's called training on synthetic data, that has diminishing returns. It gets worse and worse and worse and not just music, but for visual works and for textual works as well. So we will always need human authored works to feed the AI machine, I suppose.
Kind of a dark future.
Yeah.
I was just going to add to, or maybe respond in part to Professor deMaine's question. So I was wondering, as we're talking, what would it look like if copyright didn't apply to works that are, as we already know, like works not generated by humans are not going to receive copyright protection? Does this just mean that there might be services out there that will compete on the experience or the features? If I want to listen to lo-fi beats to study to or to sleep to, I'll use the app that works best. It doesn't really matter from a business perspective that these apps can't protect their music, their AI generated music through copyright, if they're just delivering it, let's say, as a stream that the user is going to listen to. Are there just certain business models where the risk of copying isn't so important because the thing you're competing on is the delivery of an experience?
It depends on the experience, because in your example, if it's just a straight, I have this playlist and it's got X amount of tracks on it. If there is no copyright protection there and there's nothing else to protect those interests, then what's going to stop the next company from coming along and saying, like, I didn't even build the AI machine. I didn't like build the infrastructure. I'm just copying it and I'm going to put it on a playlist on my own system and not invest in it at all. That being said, I do know of companies out there who, for example, are doing really interesting things, maybe not necessarily in the copyright world, but this is something that I heard about earlier this year out in Anaheim at the NAMM show. There's a company that monitors your brain waves and then changes the AI generated audio output to adjust it in certain ways to get you to focus better, which I find really interesting. I think they suggested that this would be very good for studying. It's like background music,
like binaural beats type stuff.
Yeah, and I mean, I'm not the technologist, so I can't talk about this any more in depth than that. But that's not copyright, and it's very interesting, and would be very harder to replicate because the input it's getting is from your brain.
I wonder. I want to ask Matt more about this too. I was just going to add, like, I'm imagining the idea that we're always talking about copying being the cheapest thing and the easiest thing and the thing that we're worried about. What if just generating the music is actually cheaper? Like, I can spend less money just simply by deploying a model on my own systems. It's less costly to do that than it is to copy, you know, some music stream and try to reproduce it. So I'm just imagining a world where copying is not the central thing we're worried about as much.
Well, to your earlier point, like about the experience, like it's already happening. So there's been a real push as companies that are like generative companies are trying to figure out what they want to be and how they want to participate, right? And on sort of prompt-based music, there has been a rush, in my opinion, really in the last like 6 to 12 months on AI companies trying to acquire the rights from independent and small labels to train on their content for this exact purpose. And it's interesting because there are now businesses that are running opt-ins for this, right? Like, I have the rights on the publishing side, I have the rights on the sound recording side, I can deliver all the rights on a worldwide basis. And there are now businesses sprouting up from this. And it's interesting because when I worked for a company called MediaNet, we delivered sound recordings. I think we had at that point a catalog of 100 million, 120 million sound recordings. Like, half of them didn't have a play. And that's held true. Like, very, like, you're sitting on these massive catalogs of music and only half of them are ever used. So you can follow the royalty train on that, right? So you end up with these aggregators now that are sitting on tens of millions of sound recordings that have no plays, no revenue. And they're thinking about going back to them and saying, well, would you like to opt into an AI licensing program where we do a rev share or some sort of revenue pool where you can contribute, where we will license out your data so that other companies can train on it. But then there's a revenue scheme and maybe you can make money. Maybe you as an artist can make a little bit of money on something that has sat on a hard drive for 10 years, right? So you see like that benefit of it potentially, but I like that because each artist has that opportunity to say yes or no. They're not brought in on something, right? Or some terms of service you signed 10 years ago and you're like, oh wait, you can still like that. There's been that too, where everyone's like having to go back and reread what they did, right? Because they're like, well, you can't, I want it in a model and I want to have some choices on which companies can do it and that sort of thing. So it's interesting. I mean, it's happening. And again, like the good actors, the one that you hope you work with, are making those phone calls and having those conversations and writing those checks and doing that. And so you want to focus on those, right? So, but it's happening. It's exciting.
I think that's fascinating because in the world of patents, you know, patent pools have served this important function in technology markets, and there's certain types of patents that are only valuable if you license them collectively. So I've written about and studied patent pools quite a bit, and this idea of creative works not valuable on their own, but valuable because there's a collective licensing mechanism that exists in the market where you can opt in and draw some revenue stream from an IP asset, traditionally patents, where otherwise you wouldn't have been able to license it individually anyway. To me, that's super interesting.
I have one more question. I have one more question for John here, and then I think we'll open it up to our audience, both online and in person, for questions. But John, this is a capacity question for the Copyright Office. Are we looking at lots of potential, or already is it happening, you know, thousands more copyright registrations, and I certainly think probably litigation? And is there concern at the Copyright Office that you're all going to be overwhelmed?
I don't think that there's concern that we'll be overwhelmed. We used to joke that the question of how many AI registrations are you getting, we actually got that question more than applications for registration. It is catching up though. So it's over. We have two. Now this is maybe dispelling some ideas about the office, and that we won't register work that has an element of AI generated component to the work. We've registered over 2,000 now. 2,000 works that can contain an element of generative AI in them. But those will be anything from people have to disclaim these. We used to get registrations that didn't disclose that they were AI, or that the examining didn't know the context. So it might have said Mid-Journey on the graphic novel, but they didn't know what that was. And so we might have had to register that and then cancel it and then register only the human created parts. But there are other examples where it's very obvious, where it's my conversation with ChatGPT, right? Like this is not an atypical, submission for a text-based work. And there have been some more interesting ones as well. Certainly, we were talking before about neurodivergent people, but people here probably know this, but maybe not everyone. Well, Randy Travis registered a work created in part by generative AI with the Copyright Office, and took a conversation to make sure, hey, what is the portions of the work that are created by AI? And it was only Randy's voice. So Randy has lost his voice, unfortunately. He had some speaking capability, but can't sing like he used to, unfortunately, but still wants to create music. He's a great musician. So used generative AI, and he has a person who sounds a little bit like him, probably created a voice model from his works. I don't know exactly the other components that they did, the people that talked to Warner and figured out exactly what was the human contribution. Well, the only thing that they had to say was a little line on the registration that said, some of the vocal components were created by using generative AI systems, some phrase like that. But the rest of the work was a sound recording like normal, the drums, guitars, everything else. And so it was very easy to register a work like that. And so, when we think about technologies and talk about what, generative AI or other AI would look like in the future with respect to music, it is somewhat similar to kind of what we've had people do before, which is, hey, I had this sample that I'm going to disclaim, right? Or I had this, auto-generated drum track that, I didn't author, so I'm going to not register that part, but the rest of the work is okay, and that's fine. As long as you have enough human contribution, we're okay. So we're not getting overwhelmed, but it's kind of been changing the focus for the examiners to make sure that they understand like what ChatGPT and Mid-Journey are and things like that. And I will say that we got a lot of attention 2 years ago, just a couple weeks over 2 years ago now, when we put out our new registration guidance. But we're going to be updating that guidance this year. We're going to be having listening sessions in the next couple of weeks to hear from the different industries about how our guidance has been implemented by them. There's been interesting kind of frustrations with having to disclaim certain works, but it just to be clear, you only have to disclaim the parts that are more than de minimis. So for example, if you had a movie and you translated a stop sign from saying stop to Spanish, like people wouldn't think that is significant enough to have to disclaim. But the question of what is more than de minimis, I think, has confused people, especially in the movie industry, strangely enough. But in any case, we're going to have more guidance on that, and I think that will be helpful for people. But like I've been saying, it's not so different than what we've been doing before, which is helpful. Not overwhelmed.
Great, thank you. And Mike, I feel like I've shortchanged you a bit. Any final thoughts before we get open to the Q&A?
You didn't shortchange me at all. One thought that just came to mind as we were speaking, I know I mentioned people who are neurodivergent who might have opportunities to create music where in the past they wouldn't have been able to become authors. Also, I neglected to mention people with motion disabilities. So imagine somebody with, for example, I read a news article about someone with cerebral palsy using AI tools to create music where in the past she had a creative spark, a creative notion to create music. So this idea of not just facilitating creation or having more authors, but the idea that we could have a broader range of authorial voices, to me is really significant. It's significant legally and as a business matter, but also just as a culture. It's exciting to me to think that people with unique human experiences could translate those experiences to music, and we might be able to learn a little bit more about what the human experience is in a more complete way. So for me, that's super. It's exciting. I'll stop there.
I think that's interesting because I think about my grandmother who loved to play the piano, but as she aged, her hands became too arthritic to play the piano. So even as we age, perhaps this can help us. All right, so let's open this up to the audience for Q&A. We have a microphone. Sorry, on the other side, if you'll line up over there, that would be great because we need to get this for the people online. And we are taking questions from those of you who are online as well. Okay. So do you mind waiting for a moment? We'll take this question from the chat first so we don't lose track of it. How are you detecting AI in works if someone does not disclose it? I think that's a question for John.
Good question. So we need people to disclose it. That's requirement. Like I kind of phrased before, there might be some signals where it says my conversation with ChatGPT or something to that effect. But if, fun fact, you don't need to register work to get copyright protection in the United States. You do need it to get extra protections, including the availability for attorney's fees or to go to court for domestic works. That being said, if you get to court and there's discovery and there's a question of, wait, wasn't this created with generative AI? There's something in the Copyright Act under Section 411 that allows the courts to ask the registrar, would you have registered this work? Would you have known that? And although I haven't gotten that particular case yet, that's not a position you want to be in where you say, well, I didn't disclose that. And then the registrar says, you don't have a registration. And the court might kick the case out. So it's something to be honest with the Copyright Office. There are also penalties for lying to the government, but the more substantial one is getting kicked out of court, which you don't want to do.
All right, thank you, John, and to our audience here.
Okay, so I think that there is a little bit of confusion, at least from my side, when we talk about generative AI, because on one side you have the algorithm, on the other side you have the model. That are two different things, because the model is what you train using a particular algorithm. So if I train my own model using a variation autoencoder, whatever, and I create something that is my model, I recorded my samples, I use those samples to train it. Is that again part of this is generative AI, so I cannot copyright? Or since I generate the whole thing, I can copyright it?
Yeah, I'm going to say that there's a couple different points in there. To the extent you have computer code that you have written, that would be separately protected. Just ignore that for folks. And by the way, in case people, it's weird, just FYI, the cameras for us are this way, so I'm not trying to ignore the people who are speaking on that side. That being said, if the office right now, without having kind of a additional analysis on this, it is just that we are just looking at the outputs. We are not looking at kind of behind the curtain about the pieces of, is it completely, you know, trained on one artist's work, for example. There are a lot of reasons that the outputs aren't protected, but it's based on, I will say that we had a report that came out on this, and it kind of said that it's based on the technology now. Right now, the way people generate you know, outputs, and if it's 100% generated, there's no kind of editing or anything like that. It's 100% AI generated. It's done by, you know, inputting, you know, music or image or something like that, or a prompt. And there are people that say, well, maybe prompt engineering should be lead to a copyright protected output. But the way that a lot of the technology, unfortunately, works for copyright purposes is that it has so much unpredictability, where you might put in the same prompt at multiple times and get different resulting outputs. And to us, that means that the output is not the part that's created by a human, but it's due to the, you know, the model, how it's trained, how it's organized. It's due to the machine. So that is what we have said to this point, but the technology in the future may change that. It's just nothing that we've seen to this date.
Thank you, John. We have Professor Patry at the microphone. I'm going to have you ask your question, and then I want to let the person online know that we'll do your question. This is Jerry A. We'll do your question after Professor Patry's.
I'm a former professor, unfortunately. So, John, the question is for you. We say a little sure for me as well. So it's on disclaimers. And I think there's a little more context than it's something the office has always been doing. It's something the office did for a while and then stopped doing because it was a bad idea, right? So in 1988, there was the policy decision on computer programs that generate typeface. Yes, and at that time, the General Counsel wanted to have a disclaimer for people who submitted applications for computer programs that generate typeface, because she was concerned that there actually was no creativity there, that the instructions for it were identical to what the output was. So because the output wasn't protectable as typeface, the computer program couldn't be either. So there was a disclaimer requirement then. That turned out, at least from my experience from having worked there at the time, to be a bad idea. And so in 92, the office did away with the disclaimer requirement for, you know, a number of reasons. The technology had changed, so that was one reason, but the other one was administratively, it was a bad idea. I also think it's probably beyond the office's scope to do that for this reason, that if someone says entire work, right, you register, your application says entire work, and as some of the questions was, it's not clear that AI was used in part. It's not clear to me that the office should be able to say, well, even though you said entire work, and even though there's human authorship here, we're going to go beyond that. We're going to make you disclaim something you never claimed, right? And the danger of that too is exactly what you said, which is that if you go to court and in discovery, someone says, oh, well, you use generative AI, and the office didn't know about this or would have rejected it. The predicate is the office should not have rejected it in the first place. but to say that because of that, failure to disclaim something that you never claimed in the first place, you know, you're out of court, or you lied to the government, so you're subject to criminal penalties. I have to say, I question that as something that the office should be doing, and that the office really has the authority to do, to make someone disclaim something they haven't done when there is sufficient creativity there for the office to register. So I'm very curious about how that works out. And I know you said you're going to get more information about that, and maybe it will be guidance. But the predicate of it is something that I find, you know, a bit troublesome. So I'd love to hear your answer to that. Not to put you on the spot.
So if there are any law students here, I advise you to check out Patreon Copyright and feel the panic.
Please.
The panic that I feel right now is just every law student's nightmare. I think the
It's a friendly question.
So the more appropriate introduction was this is Bill Patry, copyright scholar and former policy planning advisor for the U.S. Copyright Office too. I don't know that everybody knows that, but it's
And I'm a huge fan of The Office. I love The Office.
right. These are important points. I don't know that I knew personally the history of between 88 and 92, as you explained about the example about typeface. I know that in looking about kind of disclosures and disclaimers in the application process, it goes back to registrations under the 1909 Act. We have like historic forms that we did look at for this. So if there was a blip in time, maybe that period of time was an experiment or someone who had a different view. And certainly, I think the greatest part of the office is having a lot of people who have great ideas, and sometimes those ideas are very different. Certainly, if we have public comments on the updated guidance, I really appreciate those getting submitted, but it's something that it's hard for me to just respond to right at the moment.
But
Thank
is
you.
there any place in the Copyright Act that you think gives the office authority to do that? Or is it just something you assume you have the authority to do?
That's again a hard question to answer, but the answer, if anywhere, I would believe is in Chapter 7. So that's it.
Right. I've looked at it. I don't see it.
Thank you.
All right. Thank you, Professor Patrick. I think the safe answer there, John, is it's above my pay grade. So, all right. I'm going to go to Jerry online. His question is, any ideas on what a productive research will look like for AI and performing rights? Mike, this might be a good one for you if you have thoughts on that, or anyone else. AI and performing rights.
It's an interesting question. I'm imagining, I guess I would want to ask the person who asked the question what they had in mind more specifically. So, like a performance involving a performance that's recorded where the artist is performing along with a computer system that's is somehow augmenting what they're doing. To me, that's interesting, but I guess I need a better, not better, the question is good, but I need more information to answer it well. I'm imagining like Andrew Bird, who I remember seeing in concert once, and he was doing these amazing things where he'd whistle and then loop the whistle, and I'm imagining some futuristic version of that using AI, but I'm not sure.
Well, we can let Jerry write some more, perhaps, if he's out there, and move to a question in our live audience.
Thank you for this fascinating discussion. So in the way you're talking about copyright law, it seemed to me like it had some similarity to tax policy in that the government would like us to buy homes, so they have a mortgage deduction. They don't want us to smoke, so they tax cigarettes. So I have the question about the politics of this. Who makes the decisions about copyright law, and who is going to be making the decisions about copyright law and AI? Who and how do they make those decisions?
To the extent you've suggested that, there is what we were talking about before, the incentive system is to create new works ultimately for authors to have exclusive rights and for the ultimate benefit of the public. I actually have a good answer on that, and it's the founding fathers, and it's in the Constitution. Article 1, Section 8, Clause 8 of the Constitution actually incorporates this concept, which is great because it's not anyone currently, it's not up to us. This is what the Constitution directs Congress the power to do.
And as far as decisions regarding like the copyrightability of AI works, I mean, we're all struggling with what the right balance is. I think there's this long, fascinating history of new technologies always prompting questions that go to the heart of copyright policy, going back to the earliest musical technology like piano rolls and daguerreotype, early photography, and this fits within that procession of new technologies that have prompted basic questions about what kind of creative ecosystem we want, what kind of creative culture we want to live within, and what role does copyright play within that ecosystem. More to the point, the Copyright Office is offering guidance and thoughts and also rulemaking on like what sorts of works it will allow for registration. Separately, the courts are going to develop law. We're expecting jurisprudence to develop around some of this as well, perhaps apart from the question of registration as the Copyright Office sees it. So look to the government, both the judiciary and the Copyright Office.
So are you saying that it's primarily the supervision of this is in the courts and in the Copyright Office, and so it's sort of an aggregate of opinions that accumulate? It's not a matter of legislation. It's not a matter of people lobbying for it. It's a matter of individual minds coming to decisions on individual cases that accumulate into a consensus. I'm just interested in understanding how the process works.
It could be legislation as well. Congress may, if it wants to, amend the copyright law, and it's done that historically. There's been a number of amendments to the copyright law, so we may eventually see the development of further refinements of the Copyright Act.
I mean, which is why it's such a benefit in the United States, because this is not, registration doesn't work like this in other countries. And I will just add on, the Copyright Office is a part of the Library of Congress. We advise the legislative branch. It's actually there is another piece of the government that does advise the executive branch on this, and that's the Patent and Trademark Office. They have a small policy shop who advises on copyright as well, despite the name of their organization. So.
And just as to throw my 2 cents in here, even though I'm moderator, there's absolutely lobbying on these issues. Absolutely. The Disney company, to name just one, so much lobbying about copyright. And we don't have any further clarification on our question about performing rights, so I will turn to Robert Midas.
Thank you. So we represent a lot of musicians who I think have very strong identities, like the late John Prine, my wife Carrie Newcomer, Sufjan Stevens, Bon Iver, artists like that I've had some comfort in believing if you replicate their music, their fan bases will know it and care. And it's knowing that Bob Dylan wrote Blowing in the Wind that matters a lot. It's not just that if that was created by AI, that it would have the same effect. So from a commercial standpoint, a lot of the artists we work with seem to be protected, at least in my imagination. But there's a whole set of commercial music out there that nobody really cares who the artist was, and in film and all throughout. And so you could comment on that, but my real question is this idea of the uncanny valley problem. Is that something that protects us, that people, when they know it's fake, care and their judgment is? And what I would suggest is don't be too sure about that, because we also thought seriously that facts mattered until recently. And now maybe a majority of America, even knowing something isn't true, decides normatively that they don't care. And so it changes society quickly. And how does that tie, I mean, very deep question, to evolution of humanity? So a small question there, guys.
Well, I'll just cover evolution backwards. No, from what we're seeing, I think you're right. I think certain artists enjoy protection based on the uniqueness of their work, right? And I think that the industry is figuring out where that matters, right? I mean, again, my musician colored glasses is that if you change the language of an iconic performance, it's not going to be the same. There's also, we're running into the idea of replacing music inside of a video or an asset. So like think about a movie or shows created in the UK under a blanket license, and now that's 20 years old, and now they want to, Netflix or someone wants to grab it and show it in the United States, but they're blocked by a handful of compositions. They've cleared the sound recordings, but they can't find the 7th writer of the something, and the show is blocked. So now they're like, okay, well, if I can go in and I can take a model that isolates and removes the music, I can replace it with something similar, right? That I can license, and I can start to redistribute works. We can redistribute these videos. In that particular area, I'm not sure it matters. Like, I'm not sure. I'm like in the background of something else with explosions and this and that going on. Like, doesn't matter, right? But as a music forward service, as something that you go to experience, like, I think those are going to be vastly different. So I think you're going to see that the industry kind of segment itself by the value of music. I think as it goes down and becomes more of a nice to have, I think, it's going to, yeah, it could all become very gray and the same. But I don't know if it changes the experience. And I also don't know if it props up the top end of the industry more because it's more unique and more, right? So I think it's just going to, use case is going to drive that considerably.
Yeah, I could jump in a little bit. I think this is a fascinating question, really. Like this fact that we're living in a moment where reality is less sure. AI is showing us things that are not real, and there's some debate as to whether reality is something we can know, whether an objective reality exists. And AI is showing us almost, a friend of mine described an image generator program as showing us glimpses of other universes, like a multiverse, But you mentioned human evolution, and I would love to know more about what you were thinking. In the context of music, I'm thinking about the role that music plays in connecting people and in sharing our human experience. It goes back to the points I was making about maybe having a broader diversity of experiences shared through music. And this role of connection that music plays is so important. And yet we're seeing music now, if you're we're seeing AI perhaps able to augment that and connect us more, to hear people and connect with them in ways that we wouldn't before. On the other hand, 100% AI generated work is like, there's no human experience there at all. Or if there is, it's aggregate and diffuse and sort of, filtered through algorithms. And these are fascinating questions. Like I could talk all afternoon about it or listen to someone talk about it all afternoon. So.
Yeah, I was just going to add on that there are other, of course, areas that AI is creating challenges, and we are, the policy people in the world are working on solutions, including on digital replicas, which is not what we're talking about now, but is a very important question. But the music world is so weird. We already have an element in the 115 license where someone, like Birdie could cover Skinny Love by Bon Iver, right? That already exists. And I will add, with the protection, it is, talked a lot about the incentive system, but that is a very financially focused part of the basis of the law. If you talk to creators, there's an element that gets talked about in other contexts, but maybe not that. And it's just being very upset. A lot of, whether you talk to an artist about, oh, I wrote this song and I think someone stole it for a shorthand, and maybe they didn't, but they get very personally attached to their music. And that's an element that, like, I hear a lot and I've heard it about in the past about maybe infringement that did or didn't happen, but I hear about so much more now in the context of, I don't want my work to be trained on by an AI system and contribute to some other work that would compete with mine. It is not just financial, it's very personal to artists, and I very much appreciate that.
If I can put you on hold for just a moment, Jerry has written back to say, performing rights in this case is composers and songwriters claiming royalties for public performance of their music. So if AI is used to create lyrics and melody, what becomes their fate with performing rights organizations? I'm not sure who among you wants to take it. Do you want to speak to that?
Yeah, as far as performing rights organizations go, public performance rights, part of the bundle of rights that you get as a copyright owner. So if you're using AI to help you along the way or to generate some part of the music, then there's a potential infringement issue if somebody is publicly performing your work. There's a system in place to ensure that also certain, public performances, like of a recording, for example, are lead to licensing stream for the copyright owner. As far as recording rights organizations go, I have to say that is above my pay grade. I don't know. It's an interesting question. I don't know if others on the panel know.
I'll put on an old hat. So when I was with SOCAN, Performing Rights Organization, so this is a this presents as a real challenge, like to me, because if you're in the United States, if you're a venue and you have music and you get a license from ASCAP, BMI, or CSAC, right, for the performance of music inside of your venue, and then you have that money goes to the PRO. It's then doled out to songwriters, right, by their data, and usually market share and radio play and all that stuff comes into that sort of to help figure out who pays who for how much, right? If a venue were to just take the app that you had mentioned that just is generative and runs it in the background, right? And that becomes your coffee shop soundtrack. I don't know. I don't know where that data comes from. I don't know, some of the generative models are keeping receipts upon creation. So here are all the labels or all the rights holders that I did deals with. Here's all the music that went in. There can be a receipt there. There's also companies that are trying to figure it on the way out, trying to figure out attribution engines on the outside of generative models. It says, oh, it's 5% from this, 10% from this, 5% from that. In either case, I don't know how that data communicates to PROs. So it's a really interesting one, and it could potentially be for a coffee shop owner. It could be a way of avoiding these things. So that's a really good question. It's really interesting.
Yeah, I would just add also, your comments, Matt, made me think contract law is likely to play maybe a more significant role in this space. I think it's a great question. Thanks for elaborating, Jerry, also on this question. I think it's fascinating.
I do want to get one more question.
This is a good question. I would take it in a slightly different context. So the issue of, do these people get paid? And at least I can answer on the mechanical side. If it's 100% AI generated, we were asked by the Mechanical Licensing Collective whether we should be investigating this, and we said yes, absolutely you should, and you shouldn't be paying for 100% AI generated work. Now, we didn't know what this was in relation to at the time, but there was a person, and without discussing the merits of the case, who was indicted for streaming fraud, and the allegations are that this person created this person's credited in over 300,000 musical works in the MLC's database. Contrast that to Taylor Swift, who has like just over 100, and was taking those works and using bot farms to stream them multiple times to, in effect, defraud other creators by drawing from the royalty pool something of the total of $10 million. That person is now subject to an indictment, not by us, by the Department of Justice. So don't try to use AI generated content to fraudulently get royalties is the short version of that. That was our office's interaction is with the Mechanical Licensing Collective because we oversee it. I'm sure the PROs are very interested in preventing fraud as well.
We have one more question here in the live audience, and then we need to wrap up. So
I'll make it fast.
Thank you.
I'm Clovia Hamilton in the Kelley School of Business. I'm an intellectual property attorney. I have one quick comment about performance rights. They're a popular company that does it for musicians, is Broadcast Music Inc., and they collect the royalties for musicians. So AI is a really important performing rights issue. And my question is related. It's about voice cloning and hologram concerts and those types of performances. Are they considered derivative works? Since this panel is about copyrightability, who would be the author on those type of AI generated performances? Voice cloning, hologram concerts.
anyone want to speak to that?
I don't know if others want to jump in. I don't know much about these
Do you have an
voice
answer?
cloning tech.
I mean, I can only speak from the technology side where we've provided models and helped with the sort of like these types of performances. And from a company perspective, it's I wonderfully can raise my hand here and say, I'm not a lawyer and I don't have to answer those questions, but we do have them in-house to do this very thing, is to make sure that every right is secured either from the estate, from the artist directly, from whichever label publisher. However, it has to be cleared. And then there are companies that are doing 3D hologram models, right? And then they license it out. But my limited knowledge of that is it's all very bespoke, one-off, done very directly, very unique, because there really isn't a format to follow. We're not seeing any sort of like, oh, here's a standard form for this. It's like, we're not there yet. So, and then same thing, we can, from our perspective, we can create the voice model and we will lock it down, and we can say, we have receipts for how it's trained, and we can make sure only certain people get access to it, and right, and that sort of thing. But once it's created and leaves, it's out of our system, right? And then it's up, it's now, but we're the folks that I've spoken to in this industry, like, they're very hyper diligent, right, about who they're speaking to, where that goes, how it's displayed. They're just sort of, but it's been very one-off thus far.
Yeah, and this is, I mean, copyright as much as name, image, like right of publicity law, which varies state to state. So I wish I knew more about these kinds of concerts. I've just seen like a couple clips online, but yeah, I imagine you have to get permission from the estate or from the individual.
I love the idea that it could be a derivative work, though. All right, well, that wraps up this session.